On March 22, 2017, the Supreme Court issued a unanimous decision in a special education case, Endrew F v. Douglas County School District. What exactly did the court decide in this case, and what are the implications for schools, teachers, students, and parents? In 1975, Congress enacted the first version of what later came to be called the Individuals with Disabilities Education Act, or the IDEA. The IDEA outlines how teams of educators, parents, and specialists must create individualized education programs, or IEPs, for students with special needs so that they receive a FAPE, or Free Appropriate Public Education. The IDEA begs the question, what is an appropriate education for a given student? The Supreme Court first grappled with this issue in a 1982 case, Board of Ed v. Rowley. This case involved Amy Rowley, a girl with a hearing impairment. Her school provided her hearing aids, but her parents also claimed she was entitled to have a sign language interpreter as part of her IEP. In this case, the court decided that an IEP must be, quote, reasonably calculated to enable the child to receive educational benefits, end quote. For mainstream students like Amy, this meant being able to achieve on grade level. Because Amy was performing as well as her peers, she was not additionally entitled to a sign language interpreter. She was not being denied a FAPE. This case, however, didn't outline reasonable standards for a child who cannot meet grade level targets. That brings us to Endrew F, also known as Drew. Drew has autism and was not making much progress in his public school district. Drew's parents placed him in a private school where he fared much better academically and behaviorally, and said the district needed to foot the bill. The district refused, stating that they had indeed provided Drew a FAPE. A higher court, the 10th Circuit Court, agreed, and cited Rowley to justify the claim that schools need only provide a de minimis standard of achievement for special needs students. In other words, as long as an IEP shows that a child is receiving some kind of progress instead of nothing at all, then it counts as appropriate. Then the case made it to the Supreme Court. The Supreme Court stated that the 10th Circuit had misinterpreted Rowley. By saying Amy had received a FAPE even without the sign language interpreter, the Supreme Court wasn't saying that schools only need to provide a bare minimum of progress, but that schools can't be required to provide the best possible scenario for a student who is already making significant achievements, like Amy was. For the Endrew case, the court unanimously raised the bar above de minimis, stating, quote, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances, end quote. And that, quote, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. The court based this decision on the historical intent of the IDEA, saying the legislation was created, quote, in response to Congress's perception that a majority of handicapped children in the United States were either totally excluded from schools or were sitting idly in regular classrooms awaiting the time when they were old enough to drop out, end quote. The whole purpose of the IDEA was to create educational opportunities beyond the bare minimum, and this decision reaffirms that. Some school districts insist that schools won't see much of a change because they already hold their students to high standards. Critics of the decision say that the new standard will create a flurry of legal battles and impose additional financial burdens on school districts unprepared to make sudden changes. But many disability rights advocates say that this is a monumental decision for the over 6 million special needs students across the country, stating that they'll be able to see the impact immediately and that parents will be empowered to seek higher standards for their children in IEP meetings. In any case, with this decision, the court has taken one step further in establishing educational rights for students with special needs. The case leaves one wondering about the future of the quality of special education in public schools, however. Shannon Roan of the George Washington Law Review summarizes the issue in her response to the decision. Quote, the parents of children with disabilities will be pleased to know that their children can now expect more than a minimal benefit from public education. Yet parents seek the very best for their children, and if private schools can better provide that for children with disabilities, perhaps they are the more reasonable option for the student's progress. End quote. What do you think? What quality of education do special needs students receive at your local school?